The CPI report, Child Protection in Iowa, brought to you by Vocal, Victims of Child Abuse Laws. You can watch our program on Mediacom Channel 15 here in Des Moines. It's aired Sunday afternoon at 1 o'clock. Again, it's repeated on Wednesday evening at 9:30. Also in Council Bluffs on Cox Channel 23, it's aired every other Thursday. Time is 4:30 p.m. You can email us at vocaliowa@mchsi.com, or we take phone calls and talk on a one-to-one basis with parents, try to help them with our experience. My number is 515-276-3956, and John's number is 515-282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. That stands for Child Protection in Iowa. And yes, we do attempt to work with parents who have difficulties with the Department of Human Services. It's not called legal advice. It's simply called a friendly hint from now and again that may be helpful to you as you struggle with the Department of Human Services or the juvenile court. Now, there are some individuals who think that even helping somebody to fill out a form is an offer of legal advice. We don't believe so. We believe that the First Amendment gives us the right of association, and it gives us the right to speak. It doesn't give us the right to represent an individual in court before the Bar Association, and we wouldn't want to do that if we did have the right. So, in fact, in one case I saw recently, this is in the state of Ohio, the Bar Association's after going after a parent who is representing their disabled son. Now, do you think it's right for a parent to speak up in court on behalf of their son? Well, the Bar Association says no, you can represent yourself, but you can't represent your son in court. So some of these people have a pretty weird idea about what rights are, particularly the Bar Association. Apparently there's not enough lawyers and there's not enough work for the ones that are there. So for some reason, they believe that representing your son is practicing law without a license. Well, I'm sorry, but these are people's courts. These are not the lawyers' courts. And you might have a comment or two about that as we go along. Terrance, are these courts really the people's courts? Or do they actually belong to the Bar Association? Well, I think that I think it's time that we yank that ownership out of the hands of the Bar Association and get it back into the hands of citizenry. By the way, it's the citizens that own the courthouse. It's the citizens that pay the judges. It's the citizens that hire the clerks and make all the other things happen.
But
well,
I think it's the corporations that fund the free trips.
that could quite
expense paid trips to these travel resorts.
Yeah, that's right. Yeah, that's right. Well, if you want to hear something about expense paid trip, maybe you should collect enough money so that you can send your favorite attorney or therapist or whoever to an organization like this where they can learn something valuable that can be used in your case. We can help parents who have lawyers. They probably need the most help, but we also help people who have no legal assistance. And by the way, it is getting more and more difficult for people to represent themselves, and the rules are so complicated. Back in the 40s, all of our Iowa statutes were in one statute book. I think by 50s, even into the late 50s, it only took two volumes to contain all of the laws. Now it's 5 volumes, and you have to have an index to those 5 volumes. And then there used to be a handful, a small shelf of books called the Administrative Code. And now it takes shelf after shelf to hold the Administrative Code. There's no way that even the most brilliant attorney would have a good grasp on everything that's going on. And if the attorneys don't have a good grasp on it, one wonders if citizenry has any kind of a grasp on what's going on. One of the things that happens when they take your children into court, they engage in something called junk science. This is a conference that will be discussing junk science, held in Las Vegas, Nevada. Kim Hart holds these conferences every year. One time it was in Kansas City, so some Des Moines people actually got to go to that would not otherwise have taken the flight to Las Vegas. But these are the kinds of things that our attorneys, our therapists, and so forth should be attending, so they get some good, rock-solid information about science misused in the courtroom. You see, you can prove almost anything by lying with a scientific bent to it, and this is happening, unfortunately, all too often in our courts. And what happens is that the children are taken away from parents, or they're separated in one way or another, or they're put into some kind of treatment program that they do not need. And sometimes these people, sometimes these judges have a tendency to worship professionalism rather than the best interest of their children. Well, that's one thing that we can talk about. And Kim A. Hart at AOL.com is a good place to start if you want to. Well, here's her web address. We'll get that up on the screen for you. Kim Hart. She's from Holland, Ohio. And she's had quite a bit to do to help Vocal get started here in Iowa. www.falseallegation.org/location.htm. www.falseallegation.org/location.htm. And that'll give you an idea of what's happening at this conference. There are a number of very interesting individuals who will be there. Some of these high-profile attorneys there. Barry Scheck was one of her attorneys speaking at a conference 2 or 3 years ago. Barry Scheck was on the dream team for OJ. But he's also been working with the nanny case in Boston. That was a few years back. They lost that case. Nanny was found guilty. She was a nanny from England, and unfortunately was tied up with this business of child abuse in the United States. A child died, and of course, when a child dies, you have to blame it on somebody. So Barry Scheck was one of the experts that testified at that trial. It seems strange that although this child died in the care of the nanny, both parents were in the medical profession. Seems funny that they wouldn't have known that there was something wrong with this child. But of course, to save their own hide, they had to blame somebody else for the child's death. Well, that happens, and a lot of this stuff I look at as junk science that they use in the court system against parents. Then, if the prosecution has a junk scientist, then you have to hire an expert. And in the nanny case, I think they had 4 experts on each side. So it was the battle of the experts. One thing that we look at every 2 years is something called the retention of judges. And Terrance Walker would like to see us give a little more thought before voting these judges back in. We can't vote them in, but we can vote them out. It's called a retention vote. In the 5th District, here are judges who are standing for retention in November. If you don't vote for them, they're likely to be gone. So if these may give you an idea. Oh, that's not a judge, is it?
The judge of the judge.
looks like the judge of the judges.
There you go.
Okay. Eliza Ovram, Donna Paulson, Artis Reese are district court judges. These are full-flung judges.
They should be flung out.
Flung out, okay. There's Carol
Fully.
Egley, Carol Coppola, William Price, and Louise Jacobs. I think that I may have a story or two regarding Louise Jacobs. Louise Jacobs was in on my case, and she doesn't know anything about the Constitution and its requirements regarding jurisdiction of misdemeanor cases. She doesn't know much about a person's right to talk to a father. And in one case, she used courtroom time to tell me that I was practicing law without a license, and that perhaps my practice of law without a license should be brought to the attention of the Iowa Supreme Court. Well, Louise Jacobs, bring it on. I would like to see your definition of practicing law without a license. I don't believe that that was the case.
Well, what about trying to practice law with a license? And you're not practicing it right.
That's right. Of course, I don't believe in practicing law. I believe in doing it right the first time, don't you?
There you go.
So the 5th District is actually divided into 3 different parts. And so we have Part A, Part B, Part C, and you've already seen Part C. Part B is saved for a different occasion because not all of these judges come up for retention every year. Daryl Goodhue, Peter Keller, Virginia Cobb, Richard Klogg, Thomas Mott, and Kevin Parker serve in areas outside of Polk County, but they're in the 5th District. These people will not serve next year or another term if you say you don't want them to serve. That means a whole bunch of you would have to say they don't serve. So if they don't get retained, they will not serve another term. That's the only way that we have to deal with judges, is to vote them out of office. We cannot vote them into office, we have nothing to say about that. Only the Bar Association and the politically elected governor appoints judges. So we don't have anything to say about that. Oh, Don was pointing out here that we're going to lose one of our illustrious Supreme Court justices, not because he's a bad justice, but because he's too old to serve. And mandatory retirement will take out a fellow by the name of Justice Laverato. Okay.
Liverado.
Laverato. Okay.
Liverado.
And there's some other Court of Appeals justices that would like to serve next time around. And I seen that strange name there starts with a V, Vaiswaran. So I'll have to plead ignorance as to the correct pronunciation. I've seen some of her rulings, and I'm not entirely for those rulings. But none of these people in the Supreme Court and the Court of Appeals will serve next year if in November you say, sorry, move on, find a real job.
Well, the only ones I can say that I would actually approve in the Supreme Court would be David Wiggins and the Court of Appeals. Of course, the one you mention all the time.
Rosemary Sackett.
Yeah. The rest of them, Heck, Zimmer, and Miller. Like I used to say, if you're going to have an opinion by Judge Zimmer, the chances of justice will be dimmer.
Zimmer. Okay. Very good. I like that.
So I say the whole lot of them, vote them out. And thank goodness Liverado is getting out of there, because that guy is obviously not shooting straight when it comes to his judicial opinions, with the parse words, with the stuff left out of the opinion. We had a guy that was here a couple weeks ago on the phone talking about how Supreme Court justices intentionally, or maybe not intentionally, but through his interpretation and through what all we could see, had intentionally used false records or false facts to justify the ruling. Judge Liverado, I think, is the king of that, and I'm glad to see the king being shipped off to retirement, because hopefully we'll have a new reign in there, a reign of justice.
That's right. Okay. Well, that's what the retention vote is all about. We don't have to put up with bad judges. Unfortunately, however, their position is such that it's almost an appointment for life, because there's no way that any one person can trace these people. Now, one of the suggestions that one of your guests offered is that we keep track, that the state keeps track of these cases, the ones that are reversed, the ones that are reversed and remanded, the ones that have bad or criticisms issued against them. All of those things should be made public record. After all, they are public judges, and I think that we have a right to know what the record is of these individuals, their performance record. Then we can determine better in November whether or not we want these individuals. In the meantime, I've heard of patriots roundabout who say, let's vote them all out, with rare exceptions like Rosemary Sackett and Justice Wiggins. I think that, is it Wiggins?
Yep.
Okay. That needs to stay on, because their cases demonstrate that these are people who do a very thoughtful, careful analysis. You know, Terrance, I think we need to start writing that book for justices. Because of what we've seen, perhaps we can write one as a spoof I think one of the suggestions we ought to give the justices: never give credence to never give credence to substantial, truthful evidence if you have already made up your mind about the outcome. Ignore the evidence, go your own way. Then perhaps you're the kind of judge that should be judged on retention day. Because we've seen all too often where judges will do precisely what they want. We saw one at the Adel High School that didn't bother to take note of the fact that two individuals had First Amendment rights. He simply said, "You can't pass out literature here." Well, sorry about that, Judge. You've been overruled by the United States Constitution. Sorry about that, but that's the way things go. One of the tricky things that happens is to use this junk science in such places as protection centers. In Iowa, we have 3 major protection centers, that's child protection centers, where children are taken and to be interviewed on videotape, to have examinations, physical examinations, to do the most intrusive examinations of all, and then to have the child questioned up one side and down the other while people peer in from one-way glass observation rooms. There is one of them, those centers, I believe, in Sioux City. One of them is in Des Moines, and one of them is in Cedar Rapids. They have the same kind of protocol, same time of practice, and they all operate together under an enormous budget extracted from the state treasury. So we are operating hundreds and hundreds of examinations from time to time using this method of child protection. It does have one feature, and that is they attempt to limit the number of interviews that a child has to go through. It doesn't pay much to take a 3-year-old child through 7 different interviews by different people and to attach some kind of meaning to what they're saying, because we have to depend on the child in many cases to tell us what abuse that child has been subjected to. So they do have one major feature, I believe, that they attempt to accomplish, and that is get it on videotape, interview the child once, do it right the first time, and don't bother the child again. I don't know if they actually meet that criteria or not, but that's what happens. We had one child where the local protection center made up their mind about child abuse in this case, and the mother persisted in a different direction. So in order to make sure that it was right, the child was ordered to go to another protection center, where the second protection center came up with exactly the same report. But the mother, in the meantime, got a third evaluation, which said completely the opposite. So we have 2 government agencies who have agreed together, and you see it's 2 against 1, because the mother didn't have the real access to the medical examination that the state did, so the courts rule. And the mother is being subjected to all kinds of harassment because of that. In fact, the child was taken from the mother, and based upon the opinions of Iowa, Child Protection Center, or two centers, agreeing together. That's the way it was. That's what happened.
I wonder how much the money that's going into the uh, pockets of these so-called independent uh, experts plays a part in all this, because it'd be highly unlikely if their motivations were to get business, to say something that they might not like. So it kind of is kind of a interesting twist upon things when you have government so-called independent experts coming in and they testify exactly to what the government wants them to, and you rarely find a independent expert that's going to testify to the opposite of what the government wants them to. So I mean, I think a lot of instances, money plays a part of that, because they definitely probably would not get their business again
That's right.
if they said something that the government didn't like.
Right. Don?
So
And keep in mind that the DHS always goes back to these same people over and over and over again, because they know they're going to get a favorable ruling in their situation. It's been proven many, many times, and we only see a portion of all the cases that go through, but there's a pattern that is set up, and if you, I've come to the conclusion many years ago that if you don't, if DHS picks thing like this medical doctor or a counselor, well, you know that how it's going to end up in the ruling, the decision by these people, not the ruling, but the decision. So you just don't want to go that route. If you don't like the way DHS has been doing to you, don't continue to think that they're going to help you in the next time when they go find a doctor like this. John?
In the case that I was talking to you about just a moment ago, the court moved one step further, and they said this mother gets to see her child 2 hours per week. That visitation shall not be extended beyond that until the mother changes her frame of thinking. So until the mother adopts the same reasoning and thinking that the state has, until she's totally brainwashed, she'll have restricted visitation with her child. Now that is not the way to do business in a society like ours. I think that's the kind of things that you might expect from a government in other places in the world, but not in Iowa, not in the United States under our Constitution. But that's the way it is. Sorry about that. Well, you were talking a moment ago that they want to go to, they'd like for you to go to certain providers. For an example, one thing is urinalysis. Is one of the things that they tell people that they must get if they've been caught with drugs, or if there's any suspicion that you have drugs. They'll take your children away and say you'll get them back if you can show us 6 months of clean UAs. That's the short for urinalysis. And they also tell you where you must get those UAs, because they know where they can count on the right kind of results from the UAs, because the Department of Human Services knows where they can count on the right kind of people. They do the same thing with therapists and others as well. They know that if you go to a certain character in a blank hospital, that character will give a report which is consistent with the thinking of the government. So here again we have something called junk science. The way I look at this is you need to be very suspicious if you see a sign that says antiques made while you wait. There's something wrong with that with that concept, isn't it? So I think you should be very wary of that. You should also be very wary of any kind of a report which is by a provider that is picked, especially picked by the Department of Human Services.
Exactly.
So, and here is an example in Washington State. Of course, Washington State, you can count on them for some pretty foolish ideas. There is a place called Harbor View Medical Center, and any child who is abused in Washington State is to be taken to Harbor View Medical Center. They're trying to make that regulatory facet so that you cannot take your child to any other medical center or any other professional person who might think differently than the government thinks. So this is hot on the list right now, is this provision whereby you must use the facility dictated by the state, because the state can count on this organization to act in the best interest of the child, so long as those people are thinking the same way that the state thinks. Well, I think that we're treading on some pretty thin ice here when we let government pick these individuals instead of mom and dad picking the individuals. Any physician who is licensed by the state of Iowa should be able to do an exam of a child and to come up with some reasoning. Now, some of these specialized exams, I can see where someone might want to take 6 hours of a specialized training so that they know precisely the things to look for, but it is not rocket science when they go into some of these, even these specialized things. Ordinary, bright doctor who is appropriately trained, educated in our schools should be able to accomplish these tasks. It shouldn't have to go to $1 million child protection center. They shouldn't have to be hauled all the way from southeast Iowa up to Cedar Rapids in order to get these kinds of tests. A doctor knows what tissue is. He knows what normal tissue is. He knows what abnormal tissue is. And with a little help from these skilled organizations, training organizations, he should be able to become an overnight expert at these things. And perhaps we could close down some of these $1 million organizations that are perverting and bringing in such things as junk science into our courtrooms. Families do not need the kind of resistance that is available when these people gang up on a family and said, your child's been abused. We've got videotapes to prove that, and the child said this and the child said that. These are attacks on good, normal parents, and quite often they lose their children anyhow. And I don't know where they get off in campaigning to steal children. In just the last 2 or 3 weeks, I've seen 6 children removed from their parents. That's a crying shame in Polk County to see that many children removed from their parents. Well, someone has to watch over those children. Someone has to make room on the court dockets that are already filled so that we can consider the cases of these children. the therapists and the child abuse industry is only too happy to step in and to provide all kinds of services for these children because of the fact that their parents have somehow permitted these children to be abused or have abused them themselves. I think this is a crying shame when this happens. It will not get solved until the courts are reformed. We've heard that quite often. There are some things that we might be able to tweak on the protection side of the matter, and we might be able to help people as they approach DHS and helping them get their reports expunged and so forth. But until we get the judges straightened out, until we get the courts appropriately reformed, we will not move forward. And our parents will be under siege by government until we get some people who are bright enough and can carry on a system of government within the courts to do right by parents. We're going to talk to Terrance Walker, who has a real interest in court reform. Here now, Terrance Walker.
Thanks a lot, John. I always like your introductions. Do me justice. I am Terrance Walker, the judge of the judges. There's no one that can do it better but you. That's why we're urging you to get out this November and vote on these judges. Don't rubber stamp them yes. You know, there's a lot of judges out there that don't deserve a yes. And I would venture to say that that could be the majority of them, from my experiences. Definitely Eliza Overham. I think we should get over her because that's a judge that should be voted out here in Polk County. There is a bunch of other ones. The whole list of Court of Appeals judges that are up for attention, none of them impress me one bit in the opinions that I've read of theirs. And in a lot of cases, they tend to, in many instances, omit certain factual findings so that it could justify their political bent or slant. And that's not the way justice should be done, especially here in America. Land of the free, home of the brave. There's a couple interesting stories here. It seems to be coming to a national, coming to national knowledge now. It seems that judges have too much secrecy, too much privacy. There's a case, or there's a story out of Alabama recently, May 2nd, out of the Montgomery Advertiser, MontgomeryAdvertiser.com, in which a judge was even trying, the commission in that state tried to silence a judge for being critical of some of the members of the court. And the judge's name was, he was a state Supreme Court Judge Tom Parker. He wrote an op-ed piece in the newspaper critical of his fellow cohorts on the bench. And Parker criticized a United States Supreme Court decision that banned executions for killers who were under 18 when they committed their crimes. And then he also faulted his fellow justices on the Alabama Supreme Court for following that decision when they lifted the death sentence of a Montgomery man who was 17 when he raped and killed a pregnant woman. And what the Judicial Inquiry Commission did was that they not only did they launched the inquiry into his alleged violations of the codes, but luckily for Justice Parker, his case against him was dismissed. So there we have one instance in which the courts are trying to not only silence critics that are not on the bench, or that are on the bench, but they're also trying to silence critics that are on the bench. And then one other interesting story here. There's a couple more out of Washington. Two senior Republicans, one of them, Chuck Grassley here in Iowa, said that the judiciary's policing of itself is not up to snuff. And Congressman James Sensenbrenner said that such behavior undermines the public's perception of our judicial system and the fairness and respect that are needed to instill confidence in our judiciary. And this is in light of recent scandals involving judges accepting free trips to resorts, all expense paid trips, different corporations, lobbying organizations, or whatnot. And so what they're proposing to do is set up an inspector general that would be able to determine whether the judicial members are complying with their own ethical guidelines and to root out potential waste, fraud, and abuse. And one individual, a spokesman for the Administrative Office of the U.S. Courts, said this past Friday, on April 28th, 2006, that creating an inspector general for the federal judiciary to investigate possible ethical violations by federal judges would be a serious incursion into judicial independence. Well, I've never heard that judicial independence was something that was written into the Constitution as an enumeration of any power or a right or privilege of the judiciary. Matter of fact, there was no such provision that I can recall ever being written into any code or any constitutional provision respecting the judiciary. In fact, the judiciary does not have any right to any such independence and has not demonstrated the ability to police itself, which is why we hear constantly, recently in the past recent years, numerous stories of how the judiciary is not adequately policing itself. And one other interesting story here, this comes out of Connecticut, out of the Current.com. Recently, there was a big scandal and turmoil surrounding the fallout of a court case in which a former Chief Justice, who first told a correspondent that he was contemplating retiring, and then made it official March 15th in a letter. He not only did he delay the announcement on purpose for a unethical purpose, but he delayed the announcement of a court ruling, which may have resulted in one of his successors not being nominated, because the opinion of the court ruling was such that it would cast the nominee in an unfavorable light, and so he was implicated in the scandal. But in response to that, the legislators in Connecticut, they've scheduled a hearing on the events, and they will take no further action on a nomination for Chief Justice until all questions are answered. And it's kind of ironic in the same case that the Supreme Court in this same state ruled 4-3 that the judiciary, not the General Assembly, has the sole authority to determine how much information about court dockets and cases should be available to the public. So in essence, they're saying that we can do what we want. We can make decisions when we want. We can hide decisions when we want. We can have secret dockets if we want. We can have secret cases if we want. And the public has no right to know anything about it, and we're the only ones that could say anything about how we decide cases or how we release cases. Um, so this is put in an interesting contrast to the other branches of the government, because the executive, legislative, both the branches, executive and legislative branches, are subject to Connecticut's open government laws. Every document, email, phone record, and the minutes of every committee meeting are open for public inspection. For too long, though, the judicial branch has effectively set its own rules and standards on the openness of its operations. And not only has it been steeped in tradition, but is also cloaked in mystery, and it conducts too much business behind closed doors. And that can be said not only just for Connecticut, but for Iowa and for every other state beyond. But the article goes on to say that there are areas where light should shine on court operations, and unequivocally, vast majority of judges, clerks, and administrative staffers in the judicial branch should have the highest quality and should have the best interests of the public at heart. And in the case in which things are being held secret, I don't think that we can say that. That's all I had to say about these two stories.
Okay.
And I think we need some openness in the courthouse, because, like I said, it tends to seem like, it's kind of like the judiciary is like the proverbial cockroach in the dark. When you turn on the light, them cockroaches get to running. And it seems to me that we have a lot of cockroaches running nowadays, and maybe we should call in for a raid.
They run for shelter to live for another day.
Yeah, they do. But
and to expand their authority.
Like that commercial where they used to have the raid.
Raids here.
We need to have raid.
That's right.
Raid.
Okay. Thank you, Terrance.
Thanks a
lot. I'm glad that you're looking into some of these cases. I think we're closer. The more dangerous these cases appear, I think the more likely we are to have a citizen uprising and a point in which people will eventually say enough is enough. We're going to have good government at the executive level. We're going to have good government at the legislative level. And we intend to have good government at the judicial level. 3 branches of government working cooperatively, one with the other, but not to subvert the rights of the citizenry, and particularly to tear apart families. I saw something on television that caught my attention. Said 4 out of 10 boys have no father in their home. Now that is tragic. And government, I think we can point fingers at government for bringing about some of the kinds of policies that cause that to happen. Government isn't the only cause, because there are other factors, but I think government has a real duty to keep that family together. Taking the child out of the home and putting them in a foster home is not the real answer. When that happens, if your child is in a placement which is not with relatives, this gentleman is in charge. He, we'll see if we can get his picture back up here. That doesn't look like we're going to be able to get him situated here.
Well, maybe I can read it while you're trying to get that reestablished here.
Okay, here we go.
Oh, there we go.
There are a few people in government that that you can really trust. And when you find somebody who is helpful, you should call upon them and see if they cannot give you some assistance. Jerry Foxhoven is interested in any kind of a situation where children are in inappropriate out of home placement. What does out of home placement mean? Well, it means devastation for the children. In some cases, of course, it's absolutely necessary, but that's in a minor number of cases. But foster care, shelter care, all kinds of different placement for children is not always the greatest. So here's a fellow that you should be interested in speaking with, Jerry Foxhoven, administrator of the Iowa Child Advocacy Board, Iowa Department of Inspections and Appeals. He's in the Lucas building. There are his numbers, and his office phone number and his fax number. He can be reached also by email, jfoxhoven at dia.state.ia.us. And I really appreciate it when we have people who are helpful to families. Jerry Foxhoven is one of those individuals, I believe, who can be counted on to keep your family together and to get that child back in your home as soon as possible if the child is in out-of-home placement now. No child should be in out-of-home placement when there's a natural parent who is willing and able to have that child in his home. Okay, Don, we didn't leave you very much time for a story here, but Don has been reading short stories or short excerpts of cases that come from a book called Shredding of Families. And this is written by some expert witnesses in Coatesville, Pennsylvania, retired medical professionals. Don Burgmaier.
I have a quote here from Dwight D. Eisenhower for you that people have got a memory. January 31st, 1958. He said, "Calculations often overlook the decisive element. What counts is not necessarily the size of the dog in the fight, but the size of the fight and the dog." So I hope the parents out there are gonna keep fighting. Get some fight in yourself. It's not necessarily the DHS how big they are. The bigger they are, the harder they'll fall. Okay, I've got an article here I'll read to you here in the next few minutes before we close. Clifford had no premonition of impending disaster when he visited an old friend one weekend. A giant of a man, he had a personality and laugh that were equal to his height and girth. Iona, his friend, confided in him that her 11-year-old daughter, retarded since her bout with, let's see if I can pronounce that word, encephalitis, encephalitis, at the age of 4 was a problem. She often disappeared for hours, only to be found in the company of older boys whose attentions toward the child were suspect. Clifford walked with the little girl, but reasoning and understanding of the consequences of associating with this group were beyond the child's comprehension. The following day, little Heidi was found in a neighbor's yard in a compromising position with the neighbor's 14-year-old son. When DHS asked who the perpetrator was, Heidi smiled broadly and pointed a stubby little finger at Clifford. The nightmare started. DHS refused to investigate any further. For 6 months, Clifford endured the harassment and accusations of the assistant district attorney, DHS, and its lawyer. Iona appeared in court on his behalf, stating he had been with her when the act had taken place. It carried no weight. As they left the courtroom, the caseworker grabbed Iona's arm, wheeled her around, and snapped, "If you don't admit the assault, admit he assaulted Heidi, we'll take away your other kids. Terrified and panic-stricken, Iona acquiesced and agreed to testify against her longtime friend. She wept all night. On his return to prison, Clifford was ushered into the counselor's office. Instead of therapy, he was introduced to Mr. Spanatia, a local tailor. Cliff, said his counselor, I have some scarecrows better dressed than you. These clothes are horrible. It's an embarrassment to the judge for you to enter his courtroom looking like this. A lot of times they'll send a person into the courtroom to look like that. It damages their reputation. You're too big to get clothes off a rack, so Mr. Spanatia will measure you for a suit. Clifford was stunned into a prolonged silence. He never had a tailor-made suit, nor did he ever expect to. But he was sartorially proper at his next, in other words, he looked great, at his next court appearance, R-E-P-L-E-T-E, with a button-down shirt.
So that is replete.
Replete with button-down shirt, tie and socks and belt. His appearance did not soften the judge's attitude, nor that of the prosecutor or DHS. Again he pleaded not guilty, and again he was sent back to prison to think it over. He languished in prison for almost 3 months, his stubbornness frustrating DHS. He was finally released with the admonition that he leave the area. Clifford was psychological about his incarceration. His entire income was going toward his daughter's law school education. Frugality governed his every move. Reflection on the last 6 months, he thought, well, at least I got a new suit out of it. This was greatly appreciated, since he would be going into federal court soon. With his daughter's aid, he filed a lawsuit against DHS, their lawyer, the assistant DA, and others who had crossed his path, violating his constitutional rights. It closes here with the Constitution speaks not only for the freedom of speech, but also of trial by jury instead of trial by accusation. That was stated by Margaret Chase Smith, U.S. Senator, Maine Newsweek, June 12, 1950. Okay, John, I'll turn it back over to you.
There are sure a lot of these kinds of cases, and Richard and Lillian Dunsmore of Coatesville, Pennsylvania, have tried to capture some of the heartache in these stories that Don has come across.
That was a false accusation.
False allegations. Sure, children need to be protected, but not at the expense of our Constitution, not at the expense of the rights of families and citizens. We'll see you